You're listening to the Privacy Casebook Diary.
And in each episode, we discuss and review a data protection case or matter.
We hope you enjoy the content we share.
And hopefully, you'll learn and grow together with us.
Michael and I are two data protection professionals, and we work, in our own capacity, and we've decided to get together and just discuss some cases of interest as part of our development, our learning, and we decided to record our discussions as it might be beneficial to others. So we're taking it in turns. So this time is my turn to present a case. So next week, Michael, is your turn. So in today's discussion, we're going to be talking about Sava versus Leather Inside Out and others. It's an interesting case. It's quite complex, but it sort of touch onto the definition of who or what is a data controller. So it's quite an interesting discussion. So the background to the case is that Anthony Sava is a prisoner, and as part of his rehabilitation is also an employee of Leather Inside Out, so where they make goods, leather goods for sofa companies, etc. And Leather Inside Out is a charity which was founded by Victoria Jones, who was also who also has a criminal background. Anyway, so Mr. Sava makes allegations of criminal activities by the charities, and the charities then ask him to sign a statement to say that these allegations are false and never to make these allegations again. He refuses, and then the outcome is that the charity then creates a report that they send to the what is it called, the local
probation service equivalent.
That's it, the probation service, and to then basically remove his license to be in the community. So, and his allegation, so he responds to say that basically the report is false, it contains wrong information. Now, the charity does admit to send the report, but it does not admit to the fact that the allegation in the report are false. So as far as I'm concerned, those allegations are correct. So based on this, he then decides, or Mr. Sava then decides to submit a subject access request. And it's a constant, because it's annual, because every time he gets refused, he then submits another one. And in this submission of a SARS, he claims that the charity, so Leather Inside Out, is a data controller, but also the founder, so Victoria Jones, is also a data controller, and the charity chair and the charity trustees, or CIO, are also data controller, because they are basing these the definition of a controller based on the GDPR, and the GDPR says that a controller is a natural or legal person, public authority, agency, or other body which alone or jointly with others determine the purpose and mean of the processing of personal data. So, I mean, the case goes on, back and forward, discussing whether the individuals, so the founder and the chair and the treasurers, are controllers, but ultimately what gets decided is that they are agent, part of the charity, so they are representing the charity and acting, on the charity, for the charity. So only the charity, so Leather Inside Out, is actually the data controller. So that's the nutshell of it. But what it's interesting, they're also making a reference to another case, which is, let me just go and get it, where there was a case, hang on. So you've got, this is W.M. Morrison Supermarkets versus various claimants, where an employee was explicitly identified as a data controller. So I think, Michael, that'd be good to add to our list of interesting cases to read and discuss. But in my understanding of a natural person as being a data controller, I think I view that, and obviously correct me if I got it wrong, like in the case like of a sole trader, or say that, you know, if I have, say, I don't know, an apartment by the seaside and I'm renting it out, you know, during the winter, as an example, I'm not a legal entity in terms of I'm not a business, but I'm deciding and I'm making money out of it for commercial purposes. So I'm collecting the data of the potential tenants. That in that case, I'm a controller, but as well as a natural individual. Is that correct?
Oh, I don't see anything wrong with your interpretation there. So you can run it as like a commercial enterprise. Yeah. So in this case also, the background to the case though is that they're considering whether to strike the case out. So he made the DSAR applications. He made 3 of those, and then he made a claim to the, I don't know which court it is. It must probably start at the county court in the first claim, for first instance, and they made a claim against him as the respondent to strike the claim out, to say that that the CIO, which is the company Leather Inside Out, had already provided a DSAR and claimed the appropriate exemptions based on the criminal exemption,
and that it was excessive. Yeah.
Yeah, and so what was disappointing from me going through the court case here, the hearings, that they went into the detail what they do, because in a way this case was more to do with the rules of the white book and the procedural rules around having a case struck out.
Yeah.
And so it did cover some DP law and what a data controller is. So they covered off that point. And so at the end, the result was that the claim was to strike out the case was successful.
Yes.
But only on the grounds that the Mr. Sava hadn't made or hadn't drafted the pleadings appropriately, so it was lacking detail. So he lacked factual evidence to demonstrate that they were in fact a controller. The other two, with the Victoria Johns and Nicole Rydweg, is the second and fourth defendants. And there's a part of a provision there that came out in paragraph 30, and they realised that this would be an interesting case as well. Hughes and Colin Richards and co. That even if, because this guy's a litigant in person, he had no lawyers acting on his behalf.
That's right. Yeah. So
the judge has to sort of bend over backwards to give him some sort of justice. And yeah, here he said, so if a case is found to be defective, which his was, because it was so sparsely pleaded, that the courts can step in, or they consider whether the defect might be cured by amendment. But in this case, the case was still struck out. So even if we did amend it, there's a lack of factual basis. That was what we saw in the witness statement. So the case was struck out. So So the applicants succeeded, and yeah, I was sort of reading this case thinking actually he might win here, and then towards the very end, I was like, oh, there we are, because the parties they were processing data as what I can see his personal data. He's sending off a report to the probation service, and yeah, and he was, seems to me that he was, the case was, because he lacked appropriate legal representation, that was that probably contributed to the case failing. But I don't know what you think about that. Or, yeah.
Yes, I mean, I think, you know, he should have got himself legal representation. He might have been a bit more, you know, might receive better outcome, or, you know, to his advantage.
Yeah.
I just thought that it was, I suppose, the thought process of claiming that the second, the third, and the fourth defendant were data controllers. It was, I suppose it was a good call, but like you said, you know, it did not have hard evidence to sustain that. So what it feels like is that he was just shooting bullets to anyone. You know, one of them is going to stick. It's kind of, you know, it's kind of, that's how he feels about it, rather than create a solid case against you know, one entity.
On the facts then, because he probably didn't put that in his pleadings to say they must have been data controllers because they were handling a report which was sent to probation services, which referred to my personal data, and then maybe including any sort of criminal references, and then the recommendation. So there's an opinion about him. Actually, his license to be on release, it should be removed. So for me, it's like, okay, maybe he didn't plead that particular
he was an employee of the charity.
Reports, they said it wasn't Victoria Johns, was it, who sent the report? It was one of the third or fourth defendant who sent the report to the probation service.
Yes, but they did it for the charity. That's how I understood it. So Mr. Sava was an employee of the charity, and so the data controller here would be the charity. The fact that you know, one of an agent of the charity, whether a trustee or another employee, sort of provided or responded to his SAR, but they were doing it as an agent of the charity. So they themselves, as individuals, would not decide the purpose and the means of the data. It would just be done as an agent of the charity, because the charity was the employer.
All right. So does a trustee have some independence from the charity? So the trustee act independently, like similar to like a non-executive director? Do they have any sort of role to say, you know, part of our role, like being a data protection officer, you should be acting independently. So if you're acting independently, why wouldn't you be considered because you are controlling the means of processing yourself then, if you've got some sort of level of independence? Or as a trustee, simply an agent of a charity?
So the trustees basically.
I mean, it's just a question. I don't, you know, it's a question for thought, but you know.
Yes, the way I understand is that a trustee is a volunteer, you know, in a charity, and they have a specific role, and they're part of the board, so they are accountable in making sure that the charity, you know, fulfill their obligations and also fulfill the legal obligations, not just with GDPR, but obviously, you know, various other laws. Sorry, but they're not. Yeah, but they're not an employee. However, they are part of the board, so they make decisions for for the charity in the same way that, you know, a director would in any organization.
Yeah.
But it's a good question. You know, are
Yeah.
there?
Yeah. So, I mean, on the surface, then, so this is a case around DSARs. So that's, I suppose, it's for us as you know, who look at DSARs all the time, is that it's not just, that's why they're complex. And you've got to consider
Yes.
so this one here is, there's four people involved. Well, three people involved in this, and the charity itself.
But see, my question is, if Mr. Sava, because obviously, you know, he failed to produce enough evidence to say that the three individuals were data controllers, but if he had enough evidence, then ended up with them being declared as controllers and therefore, you know, liable. So I think, you know, your question as, you know, are trustees considered as agent of a charity, or can they also be considered as independent, is a good question and a good sort of wake up call for any charities out there, or any trustees that are, you know, or anyone who is a trustee in a charity, that potentially they could be personally liable as well.
Yeah, and there's that issues around the witness statements here. So we don't see the witness statements in this case report.
No.
And then we're looking at Victoria Johns here. So she calls herself a consultant for financial and legal affairs. She's also referred to at some point as a founder and CEO.
Yes.
And then the third and fourth defendant, trustees and leather designers. So looking at it. And also Nicola, who's the fourth defendant, calls herself a chairperson.
Yes.
So you have to look at what roles they did actually play in the organisation. And another piece to consider then is that the charity as well is gone into administration.
Yes.
Potentially it's going to go into liquidation too. So there's the issue then, if the controller's in liquidation, what can you do if it's in liquidation? There's no company any longer.
Yes.
And what can you do if the DSAR would fall away then, if that's the case? Or would they have to go to wherever the data is stored for?
Or maybe
what happens there? So these issues haven't come up, but they're sorts of things that actually that could happen, which are sort of relevant.
Or would
so I think mainly.
Or would the administrator, you know, the one that handles the liquidation process, would they then become responsible for the SAR?
I guess they would.
During the liquidation process.
Yeah, responsible for providing the data. Yeah. Well, maybe that's what they were in this case already.
Yeah. You know. So yeah. I mean, there are some, you know, unanswered questions. You know, the case doesn't answer all the questions, but there are questions to ask.
It's just it was one of those that was actually open to their avenues, and you think, what does it? That's interesting. What could that mean?
But it just goes to show that, you know, something that you would think simple as a SAR is not. You know, it can lead to lots of complications. Yeah.
No, I mean, I think he must have had help originally when he put the SAR together, because the letters really quite detailed. So he wrote to the data protection officer. There may not have been one at IO, but it's all profiles, entries. It's very, very detailed in what he's claiming.
Yes.
And the bank, he was a contract of employment, 0 hours contract. So very detailed. But so they refused to provide the information requested, relying on the criminal investigations exemption and prevention of detection of crime, and being disproportionate, as you said earlier on, in nature.
Yeah.
So they touched on the DSAR, but who knows where that was? Yeah, there's a bit interesting. So litigant, unrepresented, and then he ends up in the Royal Courts of Justice.
Yeah.
Yeah, there we are. There we go. Yeah.
Yeah, but again, really interesting to read, and I think it highlights certain things, certain element that we should all be aware of, and keep an eye on it.